Today, we're diving into a Supreme Court case that really gets to the heart of a huge question. Can the government literally reach into your mind to solve a crime? It's a fascinating story that puts modern investigative tools head to head with our most fundamental human rights. So let me ask you this directly. Imagine law enforcement thinks you know something critical to a case. Could they actually force you to reveal what's locked away in your own mind? And no, this isn't some plot from a sci-fi movie. It is the very real dilemma at the center of our explainer today. All right, let's get into it. The case that pushed this whole question all the way to India's highest court, it all starts with a man named Amlesh Kumar and a terrible personal crisis. So here's the rundown of what happened. Amlesh Kumar's wife disappears. Pretty quickly, her family points the finger straight at him, accusing him of dowry harassment and, well, worse. He gets arrested. But here's where it gets weird. When he applies for bail, the High Court not only denies it, but it also says yes to a police request for him to go through a narco-analysis test. And this is the moment the whole story shifts from just a tragic family case to a huge constitutional fight. Amlesh challenged that order, basically saying, "Whoa, hold on, you can't force me to do this. This violates my most basic, fundamental rights." So what even is this test that's causing all the controversy? You hear about it all the time, but let's break down what narco-analysis actually means. People call it truth serum, right? Basically, it involves giving someone a drug that puts them into this kind of hazy, semi-conscious state. The idea is that when your guard is down like that, you're more likely to spill information you'd otherwise keep to yourself. It's supposed to lower your inhibitions and get you talking.
And this is where things get really tricky. On one hand, you've got the police, who are just trying to do their job, gather evidence, solve a crime. But on the other hand, you have the Constitution, which gives every single citizen these two massive protections. Article 23, which is your right not to incriminate yourself, and Article 21, the right to life and personal liberty. It's a classic showdown.
Now, what's so interesting here is that this isn't totally new territory. The Supreme Court had actually already written a rulebook for this exact kind of situation. We've got to go back to a landmark case from 2010. That case was Selvi versus the state of Karnataka. And the final word from the court was so powerful and so clear, it doesn't matter what investigative tools you have, they can never trump a person's fundamental rights. Period. The Selvi case laid down some really clear ground rules. First off, you cannot force someone to take a narco-analysis test or a polygraph or a brain mapping test. It's just unconstitutional. Second, these tests can only, and I mean only, happen if the person gives their informed and totally voluntary consent. And third, this one is huge. The results you get from these tests, they are not direct evidence in court. They can only be used as a kind of lead, a pointer for police to go find other real evidence. Okay, so let's fast forward back to the present. The Supreme Court basically had to pull out that Selvi rulebook and see how it applied to the very specific, sticky situation in Amlesh Kumar's case. The court was faced with three really critical questions. Number one, can a court order one of these tests just to decide whether or not to give someone bail? Two, even if a person volunteers for the test, can the results alone be enough to convict them? And three, what about the other way around? Can an accused person demand to take a test as an absolute right, maybe to prove their innocence? And the answers from the court? They were pretty decisive. Can a court order a narco test for bail? A big, fat no. Can the test be the sole basis for a conviction? Again, a firm no. But can an accused person ask for a test themselves? This is where it got interesting. The answer was yes, but. So, what's with the yes, but? Well, it means that while you absolutely have the right to ask for a test, it's not a done deal. The court still gets the final say on whether it's appropriate for the case. So you can ask, but the judge has to agree. It's not an absolute, undeniable right. Okay, so what's the big picture here? What does this all mean? Well, this whole judgment is about drawing a really important line in the sand, the line between the search for truth and protecting our individual rights. And that brings us to the number one takeaway. The court made it crystal clear that a bail hearing is for one thing and one thing only, deciding on bail. You can't turn it into a backdoor investigation or a chance for the police to collect evidence. And hey, don't just take my word for it. The court's own reasoning put it perfectly. They said allowing these tests at the bail stage literally converts bail hearings into investigative forums, and that is a line that our legal system just can't cross. So at the end of the day, this ruling really doubles down on what the Selvi case already told us. It puts up a strong guardrail to protect our right to remain silent and our personal liberty. It confirms that even if someone volunteers for a test, the state doesn't get a free pass. There are rules, and those rules are there for a very good reason. And all of this leaves us with one final, pretty tough question. Just imagine, you're accused of a crime you swear you didn't commit. You know the science behind the test is shaky, and you know the results can't be used as direct evidence. But you're desperate to prove your innocence. Would you volunteer? It's a place where the line between finding the truth and protecting your own rights gets very, very personal.